Good afternoon, everyone, and thanks for joining the National Alliance of HUD Tenants webinar on HUD tenant rights under COVID. During this webinar, I'm asking that you please mute your phones. My name is Geraldine Collins. I'm the president of the National Alliance of HUD Tenants, and I will be facilitating this evening. And first of all, we're going to introduce to you our presenters for the evening. Our presenters will be Michael Kane, which is the Executive Director of the National Alliance of HUD Tenants, Bridget Simmons, Esquire, National Housing Law Project, and our special guest is Toby Halliday, which is the Director of HUD Multifamily Office of Asset Management and Portfolio Oversight. And you'll hear us say, maybe from time to time, you hear us say, AMPO, and that's what it stands for. The organization that's represented here today is the National Alliance of HUD Tenant, which is a national tenant union representing tenants and privately owned apartment buildings subsidized by HUD. Founded in 1992, NAHT is governed by elected all-tenant board with members, tenant unions at the building level and affiliate area-wide tenants organizing projects in 15 different states today. The second group represented here today is the National Housing Law Project, which provides assistance to housing attorneys and locally based legal service organizations throughout the country. And thirdly, the U.S. Department of Housing and Urban Development, which is the U.S. government housing agency, HUD Multifamily Housing, Multifamily Office of Asset Management and Portfolio Oversight, which oversees private apartment owners who receive project-based Section 8 subsidies from HUD. And what will be covered here today, we will discuss with you the type of HUD federally assisted multifamily housing covered by the federal eviction moratorium in the CARES Act, which I guess you guys have been hearing about lately. We'll be discussing that. And we'll also be discussing if you lost your job and how HUD tenants can recertify to lower rents. And we'll also be discussing HUD tenants' rights to organize and how tenants can organize to keep their homes safe under COVID. And also how HUD multifamily tenant groups can join that. We're asking you to please have your questions sent to the chat box. And right now I want to introduce to you Mr. Michael Kane, which is the Director of the National Alliance of HUD Tenants. And Michael will be covering, in this session, he will be covering HUD tenant rights and safe housing under COVID and HUD right to recertify for a lower rent. Michael, you can begin.
Okay, thank you, Geraldine. This is very exciting for us. We have 300 people registered today from all over the country. So we wanted to start by, we're targeting this messaging to HUD tenants, and there are three types of HUD subsidized rental housing that not everyone is familiar with. One that most people know about is public housing, which are buildings that are owned and administered by local housing authorities with money from HUD. They today serve about 900,000 families in the country. The second type of housing that people have some idea about are Section 8 vouchers. 2.2 million families currently receive mobile tenant-based vouchers administered by local housing authorities. Again, the money is from HUD to the housing authorities, to the voucher holders and the owners who receive them. The third type are privately owned HUD subsidized apartments. Privately owned HUD subsidized apartments. There are currently 1.2 million families in project-based Section 8 units, where these Section 8 subsidies are not mobile, they're tied to the buildings. And that's the sector of housing which NAHT historically has represented, privately owned HUD multifamily housing. And you'll notice that there are actually more very low income people who live in privately owned subsidized project-based housing than live in public housing. Not a lot of people are familiar with that. The rules are somewhat different in the different programs, but what they all have in common is that tenants are paying 30% of their adjusted family income if they're in any of those three types of HUD rental housing. And that becomes important under the CARES Act, as we're going to see today. Another observation that's important is that there are only one, it's not an entitlement, so only 1 in 4 families who need and qualify for these programs are able to actually get them. It's like a lottery almost. So that's why there's so many homeless people and so many other people in private housing that are really hurting. So COVID has happened. Congress passed the CARES Act, and people always have had a right to safe and decent housing in HUD housing and everywhere else. There are housing codes that people can use to enforce that locally. But in the CARES Act, HUD provided additional money to owners and housing authorities to deal with the COVID crisis. Specifically, Congress provided $1 billion for HUD and for Section 8 owners, private Section 8 owners, and $685 million to HUD for public housing agencies. And that money is for 2 purposes, above and beyond the basic subsidies that have already been provided by HUD to both of those programs for many years. The purposes are to cover the rent loss for tenants who lose their jobs and therefore income. Congress is making up the difference by giving the money to the owners and housing agencies for lost income, lost rent rather, if tenants can't pay. And secondly, to pay for COVID-related health supplies, sanitizers, masks, and so on. So we want to emphasize here and throughout today that you have the right, tenants have the right to organize and advocate for safe practices under COVID in your buildings. If the management is not doing safe practices, we've had all kinds of complaints about this, you have the right to speak up. And now that the CARES Act has passed, as you learned today, you can do so without threat of eviction or retaliation by the owners. So it's a great opportunity to organize, not just for the immediate safety, but for other purposes as well. So these funds supplement the basic money that has always been there, but it's no excuse. If your management or owner says, or the housing authority says, we don't have the money, it's not an excuse. Congress has given them the extra money to deal with this crisis. So one of the aspects of this is if you are in one of these income-based HUD subsidized rental apartments, you have the right to recertify for a lower rent. You all have a right to, because you pay an income-based rent, you can request an immediate interim rent recertification from the owner or the housing authority to readjust your rent, and if your income is dropped. The owners of project-based Section 8 housing must consider this request, and it would be effective the first of the month following the date of the loss of income. So for instance, if you lost your job, let's say it's the middle of May, you haven't signed up for this yet, but you lost your job in March, you can request a recertification based on your new income, which could be 0, and it would be effective the first of the month following the date you lost your job, effective the 1st of April. So you could actually get a rent rebate in that example, let alone pay less going forward. For public and voucher housing, however, it's a little different. The effective date of the interim recertification varies. It's determined by the local housing authority. It's usually the first of the month following the request, but we believe that they have some discretion on this, so you should certainly push to get them to be more flexible. And then we have to mention that there are some tenants, perhaps somewhere around 70 to 100,000, that have enhanced Section 8 vouchers from HUD, which is a special program if the owners of private housing had gotten out of their contracts in the past, they were given Section 8 enhanced vouchers. Tenants with those vouchers can request a recertification if their income drops more than 15%. But the payment standard going forward would be the same percentage as it was before when you converted to enhanced vouchers, which is usually higher than 30%. So that's one difference. Let me find that. There you go. So the last thing to say on this, or on these slides, tenants are required to document your loss of income. in order to get a rent reduction. So if you, like a layoff notice, for example. Uh, since COVID, HUD, and you're going to hear from Toby Halliday in a minute, who is the HUD representative responsible for HUD multifamily housing. HUD will now allow tenants to submit recertification requests in writing by mail, email, or fax. You no longer have to make an in-person visit if it's not safe to do so, and or if your management office is not open. So HUD has softened the rules so that you can make a request in writing in those methods. Secondly, if the documentation to prove your loss of income is not available, let's say you were working for a restaurant, the restaurant's bankrupt and closed, you can't locate them to get your documentation, you can submit a simple written request, which they will consider, now they're supposed to consider it, provided the required documentation and what they call wet signatures, which is an actual, your signature on a piece of paper, is provided at some point in the future. Could be a few months, whenever the COVID crisis passes. So those are two things that HUD has modified their normal rules for recertification to make it easier for people under this crisis. We should mention that some people may have zero rent, and up until recently, in fact, it's still the case, owners typically charge a minimum rent of $25 a month if your income goes down to zero. So there are people that have zero income that are paying $25 a month, which is a hardship for them. And in public housing, it's usually more. It's typically $50 a month in public housing. It can vary depending on the agency. The current rules that say that they will consider, the owners or housing authorities will consider a hardship exemption request from a tenant. You have to ask for it if you cannot afford even that minimum rent. And there will be a lot of people with 20 million unemployed who are in that situation. So you can request that. It's kind of a hassle for you and the management, but you can do that. So if your income is dropped and or if you can't pay the minimum rent, ask for an interim recertification or a hardship exemption as soon as possible when your income is dropped. So that's about interim recertifications to get a reduction. For annual recertifications, the rules have similarly been modified. Owners are expected to maintain the same timetable. So if your lease renewal came up on April 1, the owners are expected to, or May 1, are expected to recertify you as of that date. But if the documents for recertification are not available, they may accept, according to HUD, owners may accept your statement, simply a statement that you can't get the documents with some brief explanation. It doesn't have to be an affidavit or anything formal, but a note, a personal note saying that in writing, as long as you get the required documents later on. So it's similar to the interim policy. They've softened it. They could do a little more, which we're going to talk about today with Toby Halliday. Another important point, and this is something that Toby clarified quite recently. There, a lot of, as you all know, the CARES Act provided a $1,200 stimulus, one-time stimulus payment per adult, plus money for children, each child. It's a one-time payment. Not everybody was able to get it, not like undocumented workers, for example, including people in HUD housing who are part of a mixed status household, are not eligible to get that payment. But most people were. In addition, if you are getting unemployment through the CARES Act, extra unemployment, the $600 a week extra unemployment, those benefits and the one-time payments will not be counted as income for purposes of calculating your rent. So that's
Okay.
a good thing. So people should know that they cannot count that towards your rent, towards calculating your rent. In addition, that is a It's a check from the government. You do not have to pay it back in your taxes next year or anything like that. It's a benefit paid out by Congress to every or most adults and children. Then,
Okay.
in addition, I've got the
Thank you,
brochure.
Michael.
Is Toby on?
Yes, Michael, thank you very much for that information. And
Okay.
later on, Michael will be answering questions. But right now, I'd like to introduce to everyone our guest speaker, Toby Halliday. He's the director of the HUD Office of Asset Management and Portfolio Oversight, better known as AMPO. Thank you, Toby, for doing this with us today. And you're on, Toby.
Great. Thank you, Ms. Collins. Thank you, Michael. Thanks to everyone who joined today. I appreciate the opportunity to be part of your call. So as I told Michael earlier, I'm glad to be with you today. I do have another meeting I need to be at 2:30 today, so I only have a few minutes, but fortunately, Michael has covered many of the main points I wanted to make sure everyone was aware of today, so I can go through some of these a little more quickly. So let me just hit some highlights, and I want to make sure I include some points that Nat had raised for me today. So first of all, recertifications, as Michael said, this is critical, especially for tenants of PBRA properties, that's properties in the Office of Multifamily Housing, that are not familiar with the recertification process. If you have experienced a loss of income due to business closures or due to illness, you should absolutely get with your landlord right away to recertify your income. You do not need to go into the office. That does not need to be face-to-face, but you do need to contact your leasing office and make sure they're aware of your change in circumstances and work through the process with them of getting them what they need so they can make that rent adjustment. We are continuing to work on our recertification policy. As Michael said, you did not need to provide an in-person ink signature today in order to process that recertification, but you will need to provide one later. And we're continuing to look at ways to simplify that process, both for new tenants who are moving in and for those retroactive or those recertifications later once the offices are open, to try and relieve the burden for tenants and for owners to make that process as smooth as possible. We do have a brochure that HUD recently issued that talks about recertifications, talks about changes in income, talks about the eviction moratorium that's part of the CARES Act. There's some good information on there. That is available on the HUD multifamily webpage. If you have access to a computer, just type into Google HUD multifamily and you'll get to our HUD multifamily webpage. The brochure is available there. Also on that page is a frequently updated set of questions and answers provided by our office on all sorts of aspects related to the coronavirus. Those questions and answers are primarily for the owners of these buildings, but there's a lot of useful information there for residents as well. So I'd encourage you to take a look at that. We are currently updating that on about a weekly basis, so there's always new information there. Finally, I shared with Michael earlier, I'm not going to try and read these over the call because that never goes very well for me, but we do have a couple of links. If folks are not sure whether they're in a building that receives HUD project-based rental assistance, that's not always a simple thing to understand because there are all these other programs, some of which were mentioned by Michael, the public housing program, of course, but there are also things like project-based vouchers and buildings that have regular tenant vouchers. So even though you know you may be getting rental assistance from HUD, it's not always clear whether you're in a project-based rental assistance building. There are a couple of links that will help you understand whether you're in a property that has PBRA and also whether you're in a building that has mortgage insurance from the Federal Housing Administration. Those are both critical for understanding whether you're covered by the eviction moratoriums that were in the CARES Act. And there's lots of information on that on the web, but Michael does have and can share with everyone on the call the links to find out whether your building is either an FHA insured building or is receiving HUD multifamily rental assistance. In that tenant brochure I mentioned earlier, there are a couple of extra pages at the back that have contact information for what we call our performance-based contract administrators. So these are agencies in almost every state around the country that help HUD make sure that conditions are being met and kept as they're supposed to be kept in all of the buildings receiving project-based rental assistance. So those PBCAs, as we call them, are really the first line of contact for residents who are having issues in their buildings. And I mention this because, as you may know, because of concerns about safety and health, and particularly concerns that residents have about having people come into their units, which is certainly understandable, HUD has suspended inspections of most of these buildings. And so we're really relying on tenants to let us know if there are issues that are sideways in your property that we should know about. And the first place that, the best place for you to contact is the PBCA for your area. So the contact information for all of those PBCAs, again, is at the back of that tenant brochure. It's on our website. It's available from NAHT. And in many cases, it will be posted in your building so you can find that information easily. And as I mentioned, that brochure also has information on evictions, both the 120-day eviction moratorium that's part of the CARES Act that may be covered later in this call, and also eviction moratoriums that are covered if your property is receiving forbearance, that is to say, if the loan is being put under special circumstances because of everything that's going on in the economy right now, including reduced payments from tenants. I do want to respond to some questions that Michael forwarded me this morning. So the first is, will HUD require owners to post this brochure? We are asking all of our owners to post this brochure in public areas in their buildings. It may not be available in your building. It is available on our website. It is available from NAHT, and we're continuing to try and get it out to owners so that they can post it and it's easy to find and to read. Second question, will we further clarify the interim and annual recertification process and reduce end of the year paperwork? So as I mentioned, we're continuing to look at that. We're trying to make ongoing changes to that as much as we can to make this easy for tenants and easy for owners to manage that recertification process. So the current process is in the brochure, it's in our frequently asked questions on our website, and if those are modified going forward, that will appear in an updated version of the frequently asked questions on the multifamily website. Third, the question, will HUD waive the minimum rent requirement across the board? HUD does not plan to waive that minimum rent requirement, so that does remain in place. That's something that you should continue to follow. There is no change to make. There's no plan to make a change in that across the board. And then finally, there's a question on, will HUD clarify that late fees that might be charged or otherwise accumulate during the eviction moratorium will not be collectible by owners after the moratorium ends? So we are working on an update to our frequently asked questions on just this issue. So the CARES Act not only prevents owners from evicting tenants during this 120-day period that starts on the enactment of the CARES Act, which was March 27th, but it also prevents owners from charging new fees for late payment or overdue rent. So sometimes owners charge late fees, and they may have done that in advance of the enactment of the CARES Act on March 27th. That's okay. After the 120-day moratorium ends in July, owners may charge late fees again. That's okay. But owners are not allowed to charge any new late fees or other fees related to non-payment of rent during this 120-day moratorium. So I hope that's clear. It's a little bit of a confusing issue because of the beginning and end dates, but basically no new fees can be during that moratorium. So unfortunately, that's all the time I'm able to be with you today. I do appreciate the chance to join you. Hope we'll have a chance to do this again soon. We really appreciate all the work that all the advocates are doing out there to try and keep tenants well informed and safe. And please be in touch with us if you have any concerns or issues. I'm glad to follow up on any questions offline. So once again,
Um,
thanks to
Mr. Halliday,
Geraldine.
can I ask you one question, Mr. Halliday? Is
Sure,
there
I
any
got
way, I
time
know
for
you're short for time right now, but is there any way people that have questions already in our chat box, can we send them to you? And on our network call on Friday, you'll be able to give us some answers on some of their questions?
So there is a mailbox, multifamily communications at HUD.gov. That is the standard mailbox for all questions related to coronavirus for me or anybody else at HUD in the multifamily
Okay.
region, and we're glad to answer any questions you might have.
Okay. Thank you for joining us today, Mr. Halliday. And we
Thank
look
you.
forward to seeing you again, hopefully in June, when we convene again for our annual NAHT conference. Thank you so much. And we send ours, be safe. Everyone at HUD, all of your colleagues and everything, send them out. We hope that everyone is safe and well.
Thank you very
Bless
much.
you.
Same to you.
Okay,
Be
take
safe,
care.
everybody. Thanks.
Okay, bye-bye. Okay, next up, we're gonna have Bridget Simmons. And Bridget Simmons is the staff attorney with the National Housing Law Project. And Bridget work focuses on the preservation of HUD subsidized multifamily housing, healthy housing, voucher use, and tenants' rights to organize. Take it away, Bridget.
Good morning or good afternoon, depending on where you all are in the country today. As mentioned, I'm Bridget Simmons. I'm a staff attorney with the National Housing Law Project. We're a national organization based in San Francisco, California, and we primarily provide support to attorneys who represent clients who live in federally subsidized housing. Next slide. On March 27, 2020, the president signed the Corona Aid, Relief, and Economic Security Act, new eviction actions for non-payment of rent, and it also prohibits them from charging fees, penalties, and other charges associated with late rent or non-payment of rent. And so the federal eviction moratorium is in place until July 25th. So that means for the months of April, May, June, and July, tenants cannot be evicted from, if they live in these specific properties, they cannot be evicted from their units during those months, as well as Toby just mentioned, fees and other charges regarding to late or non-payment shouldn't be levied against those tenants. So after July 25th, if an owner would like to evict a tenant for non-payment of rent, the owner must give the assisted family 30 days notice, and that notice must come after the July 25th date. Tenants are still responsible for paying rent. Tenants can be evicted during the federal moratorium period for other lease violations. So like for say in public housing, people can't smoke in their units. So if there's a continuous smoking violation, tenants could be subject to eviction under those circumstances, unless there is a state or local eviction moratorium in place. So this is slide 2. We could stay on the previous slide, Michael. This one. Okay. The federal eviction moratorium applies to specific federal housing and federally backed loans. So properties with federally backed loans, they're also subject to the federal moratorium. And so for a tenant to be protected by the federal moratorium, they must be living in these specific type of properties. And then Michael, you can go to the next list. So here we have listed the specific federal rental housing programs in which the federal eviction moratorium applies to. Most notably, you'll see that the federal eviction moratorium applies to the Housing Choice Voucher Program, public housing, project-based Section 8, Section 202 program, so that's the housing for the elderly, and the Section 811 program, that's housing for the disabled. You'll also see that the eviction moratorium applies to LIHTC properties as well as rural housing, including rural voucher housing, the rural voucher housing program. Next slide. The federal eviction moratorium, as I mentioned earlier, also applies to properties with federally backed loans. So what is a federally backed loan? A federally backed loan is a loan secured by any lien on a residential property by any officer or agency of the federal government, also including Fannie Mae and Freddie Mac. It might be difficult to determine if a family lives in a property with these type of loans. And as Toby mentioned earlier, and then towards the end of this presentation, we'll share a couple of search engines that could be helpful in determining if whether you or your client lives in a property with one of these federally backed loans. So next slide. So I've described what the federal eviction moratorium does, but the federal eviction moratorium does not stop the requirement to pay rent. It doesn't stop proceedings where the eviction was filed prior to the effective date of the federal moratorium. So before the April date, or the March date, before March 27th, if the landlord filed the eviction action, those actions can continue on if the state or local jurisdiction hasn't closed the courts. Eviction from properties regarding other lease violations that are not associated with non-payment of rent. So my example earlier was smoking in public housing units. A tenant could be evicted for continuous violation of the lease provision that says there's no smoking. So folks should be mindful of that. The federal eviction moratorium only pertains to the non-payment of rent, and then also the fees and charges associated with non-payment or late payment. Next slide. So we've been talking about the federal eviction moratorium, but then also states and localities have also put into place eviction moratoriums. So in addition to federal protections, a person living in a subsidized housing or a housing with a federally backed loan can also enjoy the protections of any state or local eviction moratorium. And so where there is a state or local eviction moratorium in place, if the state or local moratorium is more protective, those more protective clauses apply to properties that are subject to the federal moratorium. And where the federal moratorium is more protective, those specific properties that we listed before, they're still subject to those more stringent federal protections. And so we say all of that to say is like, the state might provide more protections than the federal moratorium. The federal is just the floor. And additionally, the state can also have a more broader application. So the federal, as we mentioned before, it applies to programs that are receiving rental assistance, have mortgages that are federally backed, whereas the state locality could just have closed all of its courts, or it could apply to all private housing. So once again, it varies throughout the country. And then I've included here a link on our website, which I'll also drop in the chat, that is tracking state and local moratoriums. And so we encourage you to use this search feature. It's definitely not an exhaustive list, but this is the list that we have. You can go to the next slide, Michael. So as I mentioned, the federal eviction moratorium is not a cancellation of rent. Rent will continue to be you will continue to need to pay your rent. But as Michael described earlier, you can go through the interim recertification process to decrease your portion of the rent. So the portion that you're responsible to pay, you can go through the interim process to decrease that portion, and you should as soon as possible. But nevertheless, rent will continue to be required to be paid. So during the eviction moratorium, the federal eviction moratorium, where it applies to properties, fines and fees cannot be collected. And as Toby mentioned, even after the eviction moratorium, the federal eviction moratorium has expired, the owner and PHA cannot go back and collect fines or fees for the months of April, May, June, and July. And so the CARES Act the statute, the law passed by Congress, it's a little ambiguous. It doesn't explicitly say those words, but HUD's guidance, and it sounds like Toby mentioned that they're going to update to make it even more explicit in their guidance, but HUD's guidance says that they can't do that, so they shouldn't be doing that. And so NAHT is going to seek clarification from HUD and Congress and just hold them to that point of making it more explicit so that we're all very clear. Can't charge on the back end for fines and fees. And then here, these are the links that I was referring to earlier in terms of searching to see if one of your property is within one of those rental assistance programs. So if the property receives a project-based Section 8, 202, 811, that first link, the coalition link, and then the last two links are for searching for multifamily properties that have a federally backed loan. So what is a multifamily property? Those are properties that have 5 or more units. Unfortunately, we haven't found a really great search engine for properties that have 1 or 4 units but still have a federally backed loan. You know, I think my understanding is that HUD is trying to figure out a way to have that information shared, but then also protecting privacy and private information. But for what we have right now is the search engines for the multifamily properties that have the federally backed loans. Next slide, Michael. So what, in all of this, what does this mean? So one, it's important to know if your property is subject to the federal eviction moratorium as described in the CARES Act. And if you receive a note for eviction, that you should contact a local legal service attorney so that they can give you assistance to determine if this is a eviction that can move forward, and 2, if it's not an eviction that can move forward because of the federal eviction moratorium, how to make sure that it doesn't move forward. And then also, you know, NAHT is a resource, and they have been hosting these weekly Friday calls that have been very supportive and an opportunity to share out stories and to flag what's happening throughout the country. And then also I will share our website where we have a number of COVID-19 housing related information. And that's the end of my slide.
Thank you so much, Bridget. Thank you. And I'm going to move on. We're going to have a question and answer period shortly. If you have questions for Bridget or Michael, and you can still put your questions in the chat box if you have any questions for Toby Halliday also. But right now we're going to move on to Michael. Michael will be discussing with us the HUD tenant rights to organize. Michael?
Okay, thank you. Thank you, Jerry. Thank you, Bridget. That was terrific. And I'm looking at, there's a number of questions in the chat box that I hope we'll have time to get to. Several of them are kind of on the same theme. So Bridget, while I'm talking, maybe you could look through those and help sort out. And Sandy Rollins has been sending some stuff too. So, so what I wanted to talk about here is the tenants. I want to go back to this issue of the tenants' right to organize. The fact that there is this eviction moratorium is a tremendous opportunity for people to organize in buildings where they've been, people are generally afraid to do so because people are afraid of losing their homes. There was a housing shortage before COVID. This is only making it worse. But the eviction moratorium changes that terrain. So it's important to say public housing, assisted multifamily housing, light tech tenants cannot be evicted for asserting a right to organize. You can only be evicted for endangering others under the CARES Act, you know, health and safety violations, but not non-payment and not the right to organize. So there's really, it's an opportunity to seek safer housing to organize around COVID-related issues, like making sure the maintenance workers are wearing PPE, making sure that hand sanitizer is available near the elevators, things of that sort. So people should not be afraid and should step up and use that opportunity. Now, today, it is not safe to have a face-to-face meeting. Most community rooms, or almost all of them, I think, have been shut down for safety reasons. But people are learning now to use these other techniques, like today. People are learning Zoom, learning Skype, teleconference calls. A lot of us have never used, I was really not familiar with Zoom myself until the last few weeks. So it's an opportunity to start organizing virtually through these techniques and build a sense of community within your development. So you can be creative around that. Your local organizing group, NAHT, legal services, can help you work through people who may not have access to computers, may not know how to do that, may only have a telephone. They can participate too. So we're all going to have to work to empower people to use these new techniques. But once we get there, it's really going to empower tenants that have not been empowered before to assert their rights at the building level. So once you've formed a group through Zoom, for example, or just by conference calls, you can seek a call with your manager and oversight agencies like the ones that Toby mentioned, or elected officials. You can do all that from your home. And the world has changed. We're all learning to use these techniques. So that's something that we wanted to mention today. If you are a member group of NAHT, either an associate organizing group or a tenant group that has just joined, and you want our Zoom, we can make our Zoom line available to you for free so that you can organize a call. We just did that yesterday to 2 groups in Georgia that came together, and once they got into these mostly elderly, low-income tenants, and they were able to get on a Zoom call, in about 10 minutes, and now they've got that tool to empower themselves going forwards. They were very excited about that opportunity. We were excited to help them with it. So we can make our line available to you to hold meetings like that for more than 40 minutes. If you just joined yourself, it's 40 minutes as your limit, but you can go on longer if you use our line. Now, in addition to that, if you're in HUD multifamily housing, that's privately owned, project-based Section 8 housing, or buildings that have certain HUD mortgages as well. 202-811 housing is covered. You have a very strong right to organize in a regulation that's for the lawyers on the call, 24 CFR Part 245, Subpart B. This was something that NAHT fought very hard for over a period of years. And it gives very strong protections. Among other things, it says that owners and management agents must recognize a legitimate tenants association and give due consideration to its concerns. Doesn't mean they do what you want necessarily, but they're supposed to deal with you and recognize you and respect you. A legitimate tenant organization is defined in the regs as a group that meets regularly, operates democratically, represents all the groups in the development, it's inclusive, and most importantly, from our perspective, completely independent of owners and agents, completely independent. That you are not a legitimate group if you're a company union or appointed by the management. But if you're an independent group, you are a legitimate group and you're protected by these regs. And that includes an organizing committee. When we advised HUD about writing these regulations, we insisted on that because a lot of times when you're just starting, management will squelch opportunities to organize. That's very common. And it's hard to get a group going to begin with. So we wanted to protect just a committee of people that met those standards. It's a group, democratic, and so on, to allow them to organize and get recognized. You do not have to have written bylaws. You don't even have to have an election. You don't have to be incorporated in order to meet those tests. And the regulations go on. It's very specific about the rights that you have to leaflet, door knock, post notices, distribute information. You can invite in outside organizers or attorneys to help you. They cannot be excluded from meetings. You have the right to meet without management present. I know a lot of you have had this problem where management just crashes the meeting or sends a spy or whatever, but the regulations are very clear that that's not permitted by HUD. They also establish sanctions. They say that owners and agents cannot interfere with your right to organize or harass you for that. and there are sanctions on paper that HUD could use. Now, I have to say, HUD has never really, I think there's one case where HUD has actually sanctioned an owner recently, and only recently, in Austin, or at least intervened enough to get the owner to really back down, and that they're considering sanctions. It's been a hard slog to get HUD to do more than that, but having it on record that these rights are there, a lot of tenants and organizers have made headway just by presenting that to their management companies. A lot of them say, "Oh, I didn't know that," and, backed off. Now, these protections only apply to privately owned HUD-assisted housing, including former public housing. It has converted to privately owned housing under HUD's RAD program. And the protections, they formally directly apply if they are project-based rental assistance. If they're project-based vouchers, the HUD standards they reference the same definition. Well, they claim that they don't apply, but it's really the same protection. So they do apply but only after the point of conversion, not prior to it. The regulations do not apply to other public housing. They do not apply to tax credit housing, although a number of tax credit buildings, there are about 300,000 project-based Section 8 units in 2.3 million tax credit buildings. If those tax credit buildings have some project-based Section 8, the entire building is covered by the right to organize regulations. If there are tax credit buildings with no project-based Section 8, unfortunately, these regulations do not apply. One thing that they wouldn't apply to any of these private housing buildings that Bridget was talking about, the 12 million units or families that are in private housing with underlying HUD mortgages, with the exception of a couple of HUD mortgages, like 236, that are defined, but most of them are not referenced in the HUD regulations for the right to organize. So they won't apply to those tenants. And one thing that we believe they should be applied to, but do not, according to HUD, are project-based voucher units. That's a new program. It's a cross hybrid between project-based and tenant-based Section 8. And we keep running across this problem, like the two groups we talked to yesterday in Atlanta. Big problem in Atlanta, where a lot of buildings were converted to these project-based voucher contracts. And the local housing authority and HUD say, no, the right to organize regulations don't apply there, even though they are Section 8. So NAHT has engaged HUD at the national level for the last few years to try to change that. So far, not successfully. We're going to try again this spring. So that's basically what I wanted to say about the right to organize for today. Jerry, do we have I think we have about 10 minutes, don't we,
Yes.
For questions?
Yes, go ahead. Anyone want to be unmuted and ask a question?
Or Bridget, is anybody who's read through the Bridget and Sandy? Bridget, can you do that? Any of the questions that have come up?
So a couple of questions are coming up about organizing and tax credit properties. So as Michael mentioned, the 245, the law that Michael was just speaking about, doesn't apply to tax credits, but Michael and Jerry, and I guess anyone else who are any other tenants that are in LIHTC properties, do you all have tips or ideas about ways that tenants at LIHTC properties can organize and be protected?
I can answer that impartially. The first thing is to find out whether there are any project-based Section 8 units in the building. And a lot of them do have them. So you might have a 100-unit building with 20 project-based Section 8, a 100-unit tax credit building. We read the Part 245 regs as covering the entire building, as long as there are some project-based vouchers or some enhanced vouchers. They also are covered. So there may be tax credit buildings that have enhanced vouchers. Unfortunately, if they only have regular vouchers or project-based vouchers, HUD would say the right to organize doesn't extend. But a project-based Section 8 contract would cover that. And so that's one tip. Beyond that, I think we're just going to have to get Congress to legislate on this. And the regulations that have to come out of the Internal Revenue Service. It's not a HUD program. So we've asked folks to help us draft that, but we're not there yet.
Sharon just mentioned that NAHT is advocating for the right to organize to extend to tax credit properties, but in New York State, there are state laws protecting the right to organize.
Good point. I think New York is maybe the only state like that. There's a program called Mitchell-Lama, which has had a right to organize for a long time in New York. So the State Department of Housing and Community Renewal can enforce that there. Other states have some protections against retaliatory eviction, which is a right to organize, but it's difficult to enforce it without extensive litigation.
Okay, I think that was Sandy's question. Sandy, did you have a question? Sandy Rollins?
Sandy could.
Sorry, I was still muted. No, I've been trying to filter some of the questions that came in, but when I think there's quite a few states that protect tenants from retaliation. It's not an explicit right to door knock and leaflet and hold meetings and things like that. But even in Texas, our retaliation statute protects tenants for participating in a tenant group. And so if a landlord comes after people saying you can't meet, you're not allowed to do this, our go-to is to respond in writing, writing response to your notice claiming we can't do this. Our state law protects us from organizing, and then CC it to your elected officials and to the state agency that administers the tax credits, and try to get them to back off.
Right, thank you, Sandy. I see a number of comments about when Toby talked about the performance-based contract administrators, and a number of people pointed out CGI. CGI, people might recall, was the computer company from Canada that gave us the Obamacare website fiasco a decade ago. For some reason, they were never blacklisted by the federal government, and so they actually are performance-based contract administrators for Section 8 housing in several states, one of which is in New York. Completely useless. I agree with the comments from Molly Rocket and others. Molly has asked, what can advocates do when CGI New York refuses to take management complaints from non-English speakers or deaf tenants? Is there someone above CGI that we can escalate? Well, the answer is yes, and that's Toby Halliday. So we will consolidate comments like that. If people have examples, please send them, and we can talk about it on our Friday calls and consolidate these and bring them up with HUD at a different level.
We have a question from Shalonda Rivers in Opelika, Florida.
Okay.
Shalonda?
Okay, yes. Can you all hear me?
Yes, we can.
Okay, perfect. Hi, everyone. I believe, I don't know if Bridget could touch a little bit on my question. I was hoping that Toby Holliday would be able to get to it, but I could deal with that a little later as well. Anything in reference to a hardship exemption. Bridget, could you explain a little bit about that? I guess, how would a resident qualify for a hardship exemption?
So in the federal programs, as Michael mentioned earlier, tenants pay rent based off of their income. And so in these federal programs, there's also a thing called a minimum rent. So the minimum rent is the lowest amount of rent a tenant can pay while living in a unit subsidized by either project-based Section 8, public housing, or a voucher. So in the cases where the minimum rent is too much for the tenant to pay, they can request a hardship exemption. And so with the hardship exemption, they have to demonstrate that that minimum rent is beyond their ability or their capacity to pay based off of their income. And so just like with interim recertification, there has to be documentation of that hardship with either the PHA or the owner.
Okay, so what if the resident is not at the minimum rent of $25 and even if they're paying $300 and they wanted to do, because of the COVID, and they want to qualify or ask the landlord for a hardship exemption because of the COVID. And then, so I guess the question would be, do the resident have to be at that minimum rent of $25 in order to ask for a hardship exemption?
I think the answer is yes. The hardship exemption only is on income-based subsidized units where you're paying a percentage of your income. So
Right.
there are people whose incomes are so low, like they have no income, they should be paying zero rent, right? And a lot of people are in that situation now, unfortunately. So they have the right to go and request this, but it's a big hassle. They have to document it. It's kind of humiliating, really, for them. And it's a hassle. The management companies don't like this either. It's a hassle for them. That's why we're asking Toby to just waive it.
Yeah, so in order to get the minimum rent, so for those who live in federally assisted housing, you go through the recertification process where they verify the amount of income that you have. They go through the process of doing the deductions, and they create this adjusted income for you. So when they go through that process for someone who is paying minimum rent, when they do that calculation, it's a number that is typically lower than it is a number that is lower than the minimum rent. And so that's why that particular family is paying the minimum rent, because it's higher than that 30% of their adjusted income, but the minimum rent is the floor. And so for folks who want a hardship exemption, that's for folks to apply for this hardship exemption. That's for folks who are already paying minimum rent.
Right. And one thing I can add is there's also a medical deduction that a lot of people are not aware of that they are entitled to. Seniors and handicapped tenants are allowed now to deduct from their their income, adjusted household income number. They're allowed to deduct medical expenses in excess of 3% of their gross income. So if you had $10,000 income, 3% of that would be $300. So if you were paying more than $300 in out-of-pocket medical expenses, for instance, under the COVID emergency, you may be hospitalized and recovering, and there's medical expenses related to that, like having food delivered. You can claim those expenses as a deduction from your gross income, so that you would pay that much less on 30% of your adjusted income. A lot of people, there were surveys at one point that HUD did it. There are a lot of people that are eligible for that who don't know that it's there. And a lot of management companies aren't really aware of it, and they don't like to get into it because it's a hassle for them. You do have to document the expenses. But if you're eligible for it, that could affect your minimum rent. That could lower your minimum rent below that, your rent payment rather, below the minimum rent level, if you actually had major expenses for health. So that's something to mention. We had it in an earlier version of the slideshow, but it was.
So Michael, this applies to you or Bridget. Can you explain to us in the CARES Act bill, the monies that HUD the federal government gave HUD to the owners for the tenants? How is that money being utilized, and what is it for?
Yeah, that was in the, try to explain it at the beginning. Congress voted the money to cover, like if a lot of tenants have lost income and they're recertifying, the owners will get that much less rent from them. But the federal government, HUD, will make up the difference between a contract payment amount that the owner is guaranteed. So that extra money was voted by Congress so that the money is there, so that you don't have to, the owner doesn't have to worry about, paying the bills if tenants can't pay the rent. So that's the first purpose of that additional money. The second was to make sure that owners had enough money for extra health and safety related items like sanitizer, PPE for staff, et cetera. So, but they are obligated to provide safe housing anyway. They get money from HUD in their baseline subsidy contracts, right, for both public housing and Section 8. This is additional money so that they have no excuse to not provide those basic sanitation and health-related needs. Does that answer the question? Whoever.
Yes, yes. I think Deborah Anna from Atlanta has a question. Deborah, can you unmute yourself?
Okay. It was just basically how to get the form and exactly apply for the hardship exemption. Do they just ask the management office, or is it any other way that you can get that form?
Yes, the management office. Is that right? I think that's right.
I'm sorry, I didn't hear the question.
Where do you get the form for a hardship abatement?
Right, so you would start that process with, if you live in project-based Section 8 or project-based rental assistance property, you would start that process with management. If you live in public housing or a voucher program or a mod rehab unit, then you would start that process with the PHA.
Right.
Okay, this question is for Bridget. Bridget, Ms. Myers would like to know, when does the moratorium end? Is it 7/25 or 7/24? Because her site is saying 7/24.
Yeah, so HUD apparently is using two conflicting dates in their materials. That's why I was a little distracted on the previous question. So in HUD's tenant brochures, you'll see that they use the July 25th date. And so that's something maybe we should flag for Toby, that they're using inconsistent dates.
Okay. And I think see another question here from Ashley. She wants to know, can property owners, property managers force tenants to apply for unemployment?
So I can't point to anything in the law that says that they can do that. I will ask, research, and find out, but I'm pretty comfortable with saying that they cannot mandate you to seek unemployment assistance.
Okay, another question from Danielle from Miami, Florida. She wants to know, what if her lease is a month-to-month lease? What are her chances right now with COVID? What is she has to do? She's on a month-to-month lease right now.
So a month-to-month lease, chances of being evicted, is that the question?
Yeah, I guess that's the question. Is Danielle on?
Yeah, there's a lot of, is it private housing? Is it?
Yeah. So
Danielle?
Section 8,
Daniela?
it's permanently extendable.
Yes, I'm on.
Yes, Daniela, could you explain to us your question?
Thank you so much. I wanted to know, I live in a multi-family housing development, and many of the residents, including myself, are on month-to-month leases. Do any of the provisions in the CARES Act in reference to the eviction moratorium still apply to us, although we don't have a year binding lease?
So
Michael?
That's a Bridget question.
Bridget. Go ahead.
That's a Bridget question.
That's a real.
So I would have to, we can connect offline, because I would have to think about the logistics of you having a month-to-month lease with a project-based Section 8 property. But in terms of the CARES Act and the protections that it provides, it's strictly focused on, for project rental assistance properties, you cannot be evicted for non-payment of rent, or it prohibits landlords from levying fees for non-payment. So under the CARES Act, no, it would not extend those protections. But I would have to think about a month-to-month lease, like what are the logistics and how that plays out. So I think in the end of this email, end of this PowerPoint, is my email, so we can definitely connect, or I can send you my phone number in the chat.
Okay.
Jerry, I just noted, scanning through, there was two or three questions on
Go ahead, Mike.
the lines about the what you have to report and what gets counted as income from the stimulus and unemployment payments. So the federal stimulus payment and the extra unemployment payment, the $600 a week extra unemployment, are excluded income. And even if they're telling you you have to report it, they're just wrong on that. I mean, it's just not part of the basis for calculating your rent. If you get regular unemployment benefits underlying the $600 a month, that is income that you have to report. Okay, so the distinction is the regular unemployment that you would get in your state versus the supplemental $600 a week from the CARES Act. The supplemental CARES Act money is not reportable income for calculating your rent, nor is the one-time stimulus payment. But the underlying unemployment from your state would be reportable income.
Okay.
Somebody else asks, is it an asset? No, it's not an asset.
Okay, we have a question from Carol from Pittsburgh. And Carol is asking, I'm from Pittsburgh, and a lot of landlords do not allow their tenants to organize, especially tax credit housing. How do we work around this issue? Bridget, can you answer that?
I think that goes back to the initial question that we posed. So
Earlier.
we suggested seeing if there are folks who have project-based rental assistance at the LaTeX property, and seeing if there are any state protections in and around organizing.
Otherwise, unfortunately, if it's only LaTeX, there is no federal right to organize protection. As yet, we need to fight to get it. Please contact us offline if you have a group, because we would need your help getting your member of Congress to do that. We have met with the banking staff, and they're willing to do that, but we have to, the ball's in our court to draft it at this point.
Okay, there's one last question from Ms. Nunez. She says, are there any legal consequences for a property manager who refuses to process a VAWA emergency transfer request, even though the tenant has mailed in all the required forms and proof? I'm wondering if an advocate or there are any next steps we can take. Bridget, I think you can take that one.
Yeah, that's a Bridget question.
Yes, there are consequences. VAWA is not waived. I am right now putting a link into the chat. Oh, sorry. I just sent it to Danielle. But
Can you tell people what VAWA stands for, Bridget? I'm sorry. Can you tell them what?
VAWA stands for Violence Against Women Act. And so to ensure that individuals and families who are either victims of dating violence, domestic violence, sexual abuse, stalking, and a number of other violent actions, to ensure that those folks can remain housed. The Violence Against Women Act requires housing providers to take certain actions whenever there is a triggering an event. And so even though HUD has provided all of this additional flexibilities about how programs should be ran, the Violence Against Women Act still applies, and still owners and PHAs must still fulfill their obligations under VAWA. And so what I just shared is a link to a resource that NHLP, along with another partner, developed in and around VAWA in the COVID housing crisis.
Okay, thank you, Bridget. And as some of you may know, we're going to just go on, Michael, and wrap this up. What our next steps are to build tenant power in NAHT. And as some of you may know, that NAHT is a group of organizing. We are organizing for over 25 years, and that covers over 1.2 million tenants across the country. they are part of NAHT. And we're encouraging our tenant groups of organizing committee and privately owned HUD assisted housing that we're encouraging you to join NAHT. And you can join NAHT by visiting www.saveourhomes.org. Or you can join our weekly calls every Friday. We are now having COVID calls since the beginning of the COVID started. So every Friday at 12:30, you can email us your email address at natsaveourhomes.org. I can repeat that. Email us your email address at natsaveourhomes.org. And that will be pulling together later in June. We usually have our conference in Washington every year in June, but this year, because of the COVID, we will be doing it virtually. And as you heard earlier, Toby Holiday was on. We will try to have most all of the HUD officials. They join us every year. We're trying to pull it together again this year. So join us. And also the local legal service organization can also contact the National Housing Law Project, which is, you can email Bridget Simmons. And Bridget, you can share that information in the chat box if you don't mind. And I think that's it, Michael. We're going to thank everyone for joining us today. And as I said earlier, please join us again on this Friday at 12:30 for our COVID network COVID. And we try to hear from everyone in different states what's going on in their buildings or in their states and how NAHT can better serve them or better help them. Thank you everyone for joining this evening. Again, my name is Geraldine Collins, and it's been a pleasure being your facilitator this evening. Blessings to all.